Okay, so, officer, those are my questions. If you'd stay there, Mr. Marley's going to have some questions for you.
Okay, thank you.
Mr. Marley?
Thank you, Your Honor. Officer, you have a discipline history with the Yorktown Police Service, isn't that right?
Your Honor, the Crown is objecting to that.
Sorry, I didn't actually hear the question.
My question was, you have a disciplinary history with the Yorktown Police Department.
There's an objection to that, Your Honor. The Crown respectfully submits that any type of questioning as it relates to this officer's past history with the police force is not relevant to what happened on this particular night and the specifics of this particular night.
Mr. Marley?
Your Honor, it's my understanding that this officer was formally reprimanded by a superior officer for what I would characterize as an offense of dishonesty. And in my respectful submission, to the extent that it is a formal reprimand, akin to a criminal conviction, it is proper grounds for cross-examination under the Canada Evidence Act, specifically prior poor conduct on the part of the witness.
Prior disreputable conduct on behalf of a witness.
Yes, Your
Honor. Mr. Houle?
Well, again, Your Honor, the Crown's position is that, I mean, we haven't got the specifics yet from Mr. Marley about what that is, and I suppose the objection is before the court. The court may wish to hear a little bit more.
He said a reprimanded by the police department. I don't believe he used the word offense of dishonesty, but an instance of dishonesty, presumably, although Mr. Marley didn't say it, arising out of his duty as a police officer. I would think, because otherwise, well, he could conceivably. Ordinarily, Mr. Houle, Mr. Marley, you may ask the witness to be excused during this discussion. Witness, you're asked to be excused, but you don't have to go. You can stay.
Well,
all right, is your objection, Mr. Houle, that your initial objection was that it was irrelevant? Then you said, well, wait a minute, he didn't provide any detail of, I'll say, the offense with which this officer appears to have been charged internally. I'll use that word loosely.
Since the officer's not present.
Yeah, he's not here. He's not here, but
it's the Crown's information that the officer at some point could not account for missing police buy money that was issued to him.
All right. As an undercover.
As an undercover officer. That he received a reprimand for that, but there are certainly no details and no indications that there was any form of dishonesty on the part of this officer as it related to the reprimand. The reprimand could have been as a result of negligence in misplacing the money.
Poor accounting.
Poor accounting. There's certainly no specifics indicated that the reprimand suggested in any way that the officer had stolen the money or was somehow involved in a dishonest proceeding. So in my respectful submission, given that lack of detail, it would call upon the court, I suppose, to speculate as to whether there was dishonesty or negligence. If it's negligence, it's not relevant, in my respectful submission, to the officer's evidence as it relates to this specific set of charges.
That's a fair enough statement, but cannot, if Mr. Marley puts it to the officer, saying you were reprimanded, there was money missing under these circumstances, is it not then open to the officer to say, well, yes, that's true, but it had nothing to do with dishonesty? I doubt if he would say that. He would say, well, you know, I made poor accounting. And then I'm wondering whether that might be a collateral issue with which Mr. Marley, with the answer with which Mr. Marley is stuck, because it's a collateral issue, assuming that's what the officer says. But if there's, all right, I'll leave it there, and then I'll ask for Mr. Marley to respond on that basis.
Right, thank you,
Mr. Marley?
Your Honor, in my respectful submission, whether it's a matter of negligence or a matter of dishonesty, and I have a suspicion as to how the officer will answer. In my submission, that goes only to the weight that you may place on the evidence, but the fact that he has been formally reprimanded in the past by his own police service, in my respectful submission, is admissible evidence. If my friend is objecting as to its admissibility, in my submission, it is admissible. Ultimately, what use you choose to put the evidence to, in my submission, is a matter of weight.
Hold on. Mr. Houle, this officer is not an accused, so it's not an issue. For instance, if he were an accused, he could only be cross-examined on convictions. He's an ordinary witness. Can he not be cross-examined on possible other discreditable conduct that doesn't amount to a conviction of any kind, because he's a witness, not an accused? But as Mr. Marley says, depending on his answer, I may or may not give any weight to the suggestion that Mr. Marley is going to make, especially if it's a suggestion that the witness does not adopt. Is it Mr. Marley sees it as a threshold issue that he ought to be allowed to ask the question, what you say he ought not to be allowed to ask the question.
The underlying test, sir, is still relevant.
Yeah.
But it's a Crown submission that given the essentially fishing expedition that Mr. Marley is on with regard to this witness, that it hasn't passed that threshold test of relevance.
Well, if now the officer's out of the room, but if the officer says, yeah, I used the buy money, I used $10 of the buy money to buy my partner and me lunch, something he shouldn't do, it shows some element of dishonesty, may not be as much as Mr. Marley wants it, but can it not, I think because he has some basis for asking the question, because presumably he has some type of record of the officer that shows the reprimand, whether it's what Mr. Marley suggests it's for or what the officer may say it for. It seems to me that it might be relevant to his credibility. So I'm going to allow the question, but having said that, it may be a collateral issue and Mr. Marley may be stuck with the answer that he gets. I don't know. Well, that might be something that we'll argue at the end of the case.
All right, thanks, sir.
Quick question. With regard to Mr. Friedbrain's prior record, would you be able to discuss a little bit about what can go in and what can't? My understanding was, and this is probably wrong, it's almost certainly wrong, but my understanding was if they're a witness and they're not the accused person, only the fact of their convictions can go in.
It's the other way around. If it's the accused.
I'm sorry.
Go ahead, Ken. No,
I'm just going to say the accused gets the benefit of not having his cross-examiner going into the particulars of the convictions. Witnesses do not. Sorry, Your Honor, I didn't mean to interrupt.
Not only that, an accused cannot be cross-examined as to charges because a charge is not proved. The accused is presumed innocent. A witness, on the other hand, you say, well, you're charged with, that happened in the drug importing case last week. The defense counsel said the truck driver was, there was cocaine found in his truck.
A lot.
A lot, yeah. I wasn't the trial judge and Ken wasn't the defense counsel. But defense counsel said to the boss of the accused, well, you're charged with importing. You're charged in a separate case with importing. Now, he couldn't the Crown could not have asked the accused that question, but defense counsel could ask the boss that question, not to prove that the boss was a drug dealer or a drug importer, but to allow an inference to be drawn that because the boss was charged, he might be giving evidence that would be helpful to him in his charge, which would, the charge he was facing, which would allow the inference that both Ken and Craig said, well, you don't like him because he framed you, and, oh, it's you. No, not you. Chris, where's he? Oh, there he is, there he is. You're tailoring your evidence because you're a member of the coalition and you don't like rotten cops, and that's why it's brought in for that purpose, not to prove that either one of them is a drug dealer.
So Mr. Houle could have said fraud under. What's that about? What happened there?
Not to the accused.
But to Mr. Freebrain, he could have.
Mr. Freed, yeah, he could have said that to him. And you know, it's especially devastating when
they deny it, their guilt.
Well, when they deny it, but when you say, well, you were convicted of fraud under $5,000 to the witness. Well, yes, I was. And isn't it true, sir, that was an 85-year-old woman who was a widow, and that $4,999 that you took from this woman was her entire life savings? And you know, that's fair game for a witness. It would not be fair game for the accused.
So I might ask a witness for their CPIC, or ask the Crown for the CPIC of the witness. I get that. I find out the fact that this person has X number of prior convictions. Isn't it also relevant to know exactly what occurred for those convictions?
Well, it may be relevant for the witness, but it's not for the accused because that would be more prejudicial than probative of evidence. Because then the jury says, oh, this is the type of person who would do this, and they're not allowed to think that way.
Because it's completely collateral in that.